Akwa Ibom, Ogun and Cross River State governorship appeals are slated for hearing at the Supreme Court this Thursday. Lawyers and members of the public exchanged pleasantries ahead of the commencement of the day's proceedings. In the Akwa Ibom State appeal, the court affirmed the election of the governor after dismissing the appeals of the three parties challenging the outcome of the election. Counsels in the matter argued that Umar Eno Basi and Basi Eno Umar were not the same, and the governor allegedly forged his secondary school certificate. The justices asked the lawyers if the West African Examinations Council (WAEC) gave evidence to establish the criminal allegations. Admitting that the examination body did not testify in the matter, the lawyers opted to separately withdraw their appeal. The lead justice, Abba Aji, subsequently dismissed the appeals following no objections from lawyers to the various respondents.
What the Supreme Court has done has been to confirm that Pastor Moino is not only the governor of Akwa Ibom State, but that he has genuine certificates. I think that's the more important thing, because that matter had already been decided in another Supreme Court case.
Back in the courtroom, the Supreme Court reserved judgment on the appeal by Oladipo Adebutu of the People's Democratic Party against the victory of Governor Dapo Abiodun in the March 18 election. Oladipo Adebutu of the PDP is challenging the election of Governor Dapo Abiodun of the All Progressives Congress, citing alleged overvoting, gross misconduct, disenfranchisement by violence, and non-compliance with the Electoral Act. Adebutu, through his counsel, Chris Uche, said the lower court disregarded the principles of margin of lead before arriving at the decision affirming Dapo Abiodun. Mr. Uche told the Apex Court that votes cancelled in 99 polling units were crucial in determining the final outcome of the election, stating that a total of 44,000 votes were cancelled at the said polling unit, whereas the margin of lead was about 13,000. He therefore says electoral body INEC should have conducted a rerun election, citing Section 24(3) of the Electoral Act. In their submissions, INEC and the APC argued that Section 24(3), which borders on inconclusive elections, cannot override what Section 179(2) of the Constitution stipulates.
It's sometimes often applied indiscriminately both to governorship, presidential, and legislative houses. But a jurisprudence is developing now that since the Constitution has been clear about what you require to score to become a governor, a subsidiary instrument like Electoral Act or regulation should not override the Constitution. So I think that is where Section 24, which deals with the issue of inconclusive election and INEC decision about whether to return or not, would then be identified, analyzed against Section 179(2) of the Constitution. So let's wait and see how the Supreme Court addresses the issue.
Our confidence in the judiciary in this country is very high. They have done what is right, they have upheld the rule of law, and they are not being used by spurious appellants to change the will of the people. The will of the people has been upheld to date, and we are sure that the Supreme Court will also uphold the will of the people.
The Apex Court also reserved judgment in the Cross River appeal to a date that will be communicated to the parties involved. Emanuela Ekele, Channels Television News.